Very little.
Thank you, Mr. Speaker. Appreciate the opportunity to speak on the Prisoners and Victims Claims Continuation Reform Amendment Bill. Mr. Speaker, this legislation had its genesis in the previous Labor government and was a response to a very precise, very confined situation where a group of prisoners, because of the way they had been treated by the prison system, made a claim under the Bill of Rights Act and the precedent case, the Bagent case, and as a consequence of that were awarded damages. And so that situation, and these were criminals who had committed crimes of a very serious nature, and they were criminals who the victims of whom would not at the time of the trial and conviction of those prisoners ever thought there was any value in pursuing a civil claim against those prisoners. They had no claim for personal injury, but they might have had a claim for exemplary damages for their conduct. And that's always been the nature of our criminal justice system and the victims of it. But that was a different situation where prisoners had won significant damages as a consequence of what had happened to them while they were incarcerated. And it was simply repugnant to the community's notion of justice that people who had inflicted considerable harm and injury on other citizens should, because of circumstances of their incarceration, achieve a windfall gain, whereas those victims got nothing apart from their entitlements under accident compensation and any other state-funded assistance they got. And so it was absolutely correct for the government of the day to pass legislation to correct that obvious injustice. None of that is to say, as I think the Minister has said in his opening speech, that we don't strive to ensure that our correction system, our system of incarceration, is one that does not lead to abuse of those who are being incarcerated, those in whose custody who are in the Crown's custody serving a punishment. We must do that. But it would be wrong then for those who are harmed by the Crown in the course of being penalised by the Crown to then to gain a windfall when citizens who are the victims of that windfall gain should have no claim at all. And so I have no personal difficulty with a regime that provides a greater sense of justice for victims and a signal to all other citizens is that the person who has caused them harm or damage or death should not be the beneficiary of some greater claim in the future. So this law was very important, and it was very important that it should spell out that the court should require, in the event of a future claim by prisoners who are claiming abuse in the prison system, that they should exhaust other sources of remedy, that they should go to the Ombudsman, they should go to the systems within the Corrections Department and utilise those forms before they seek redress in the courts. And so, sir, and it is also right that we should ensure that we have an effective mechanism to ensure that any abuse of power in prisons are properly redressed. And if there are concerns about the existing regime that we have, well then let's hear those concerns and let's consider what might need to be done there. Sir, because it is only part of our obligations as an international citizen that we ensure that those who are incarcerated by the state are not subject to abuse and torture. So one of the problems with this legislation, having said all that, and we will support it, we will support this legislation, but we want to place on record, and I want to place on record the concerns about this. First of all, that the original legislation was time limited because it was assumed that there would be, and it was intended that there would be a review of the sort of regime that would deal with victims' rights and that would deal with what happens to prisoners, but most importantly about victims' rights. And indeed, on one of the more recent renewals of the legislation, or the continuations of it, an undertaking was given by the government of the day, this government, that there would be a review, and that other parties would be consulted on it. And I have to say, and it may not be the fault of the Honourable Chester Borrows, who has spoken to move this reading, but the reality is none of that happened. There has been no consultation with other parties. There has been no review. And so we're stuck with a piece of legislation that was designed to deal with a specific situation, a specific injustice perceived by the community, that raised issues about the broader justice system, but most importantly raised issues about our system, our regime of victims' rights. And so we need to, that work still remains to be done, ensuring that we have a system of victims' rights that is robust, that respects the various positions and standing of the parties concerned. And so there are some alternatives. There are some who argue that the provisions of this bill should be extended to any windfall gain that a prisoner gets, whether it's a bequest as a result of a family member's death, whether it's a win in lotto, although quite how a prisoner incarcerated at the time was buying lotto tickets defies explanation to me. But any other windfall gain. Now, I don't go that far, but what I do say is that a more progressive and comprehensive system of justice that is looking firmly at victims' rights might say that there are different ways of approaching it, that redress can be provided to victims once a penal sentence has been served. In most cases, in the majority of cases, prisoners, those who are doing serious crime, will get to a point where they have done their last penal servitude and they get released, and because of a progressively changing criminal, or at least a correction system, we're now getting people back in the community without repeating their crimes, without recidivism. It is not too much to say of those who have caused significant harm and damage to others that they may have an ongoing responsibility through their future earnings, to provide support and assistance to those to whom they have caused that harm. I don't think it's beyond the realms of a broader system of justice to look at something along those lines. And there may be a trade-off in the length of sentences if indeed somebody is having served a sentence and goes into paid work, and as part of their contribution to the community to make amends for the harm they have done, to then have a further surcharge on their earnings to make good the damage they've done to their victims. I don't think it's beyond us to do that, and that would be fair. It could be considered at the time that a judge is considering sentence, and it is a matter that could be followed up and continue to be administered by either the correction system or indeed the IRD, on whom we are about to spend $1.5 billion on a computer system that should be able to handle at least that. So, Sarah, I think we support this legislation because it continues its confined approach to a confined problem, but it doesn't answer the real problem, which is a broader answer to the need for a comprehensive regime, cohesive regime of victims' rights to compensate those victims who have suffered harm beyond the personal injury, which is compensated through our ACC system, but have suffered other harm and damages as well that ought properly to be compensated. Leaving in place this system makes that a lottery, because the victim can only recover if the perpetrator of the crime against them, the violence against them, is somebody who suffers their own violence in the prison at the hands of the prison system. And that is, we know, doesn't happen to every prisoner, happens to a very small percentage of them. And in fact, a very small number, as was evidenced in this particular case, that triggered this legislation, the Tonoa case. So, sir, we don't want a victims' rights regime that is essentially a lottery system. We need one that is based on coherent and considered thought. And the coherent and considered thought has not gone into this legislation. It is simply being rolled over with some amendments, the clarifying amendments, but it does not address the fundamental problem. That was the undertaking given by this government when they rolled this legislation over the last time. They haven't fulfilled that undertaking. And even though this is an open-ended piece of legislation now, I prevail upon this government and the minister who is in the House to take seriously the wish to get, and I'm sure on all sides of the House, to have in place a sensible system of victims' rights to put to bed once and for all the repeated claims of injustice being suffered by victims. Notwithstanding all that, Mr Speaker, we will support the bill.
I call the honourable member Scott Simpson.
Thank you, Mr Speaker. It's a pleasure to stand and rise and take